In a short 24 hours, a lot has changed. This was really not the context in which I had hoped to greet you. And yet, here we are together at the end of a very, very long week and the beginning of a very tough fight. For those of you who don't know me, I'm Caroline Fredrickson. I'm the president of the American Constitution Society, and I'd like to welcome you to ACS's annual Supreme Court review. I think all of you know, but I will repeat it just in case, that ACS is a national network of lawyers, law students, judges, and policymakers who believe that the law should be a force to improve people's lives. Yes, it's something we'll have to keep repeating. After a rather slow start and a late sprint, we finally got to the end of this year's term. Some of us might say that the court saved the worst for last. After rather terrible rulings on the Muslim ban, workers' rights, and women's reproductive health, and after punting on partisan gerrymandering and claims for religious exemptions from anti-discrimination laws, the bomb went off. We are now at a pivotal moment for our country. In a moment when we would be simply looking back at this term, we can't help but question what is to come. The current court, as most people acknowledge, is already historically conservative, with rulings that have undermined the right to vote, join unions, and be free from discrimination. How will another pick by Donald Trump affect the development of the law, especially as he advanced a litmus test that embraces overturning long-held rulings like Roe versus Wade? Now, of course, it's for the Senate to vet any nominee so we can all be clear on what is the potential impact on our legal system. Many of us believe that our Supreme Court is the last hope, often, for those seeking justice against powerful special interests. Indeed, President Trump promised voters he would stand up for the forgotten in our country. Will his Supreme Court nominee do the same? But as past is often prologue, we must look back to see and understand what might be coming before us. So with that in mind, our review will take up those questions. And to lead us through the review today with a very distinguished panel, we are so glad to have Tom Goldstein, one of our nation's most experienced Supreme Court practitioners. Tom is no stranger to this crowd. He's served as counsel to the petitioner-respondent in roughly 10% of all of the court's merit cases for the past 15 years, more than 100 in total, personally arguing 41. That's quite an outrageous number, Tom. But in addition, there's more. To practicing law, Tom has taught Supreme Court litigation at Harvard Law School since 2004, previously taught the same subject at Stanford Law School for nearly a decade. He's also the co-founder and publisher of SCOTUSblog, the only weblog ever to receive the Peabody Award. And he has been named by the National Law Journal as one of the 40 most influential lawyers of the decade. So we have an expert and a wonderful colleague to have and lead this discussion. So please join me in welcoming Tom Goldstein.
Thank you, and on behalf of myself and for everybody on the panel, I wanted to thank each of you, as well as the folks watching at home, for contributing your time to this. At the term wrap-up this year, we actually know that with all of these experts, everyone here is looking, or almost everyone here is looking to hear one thing, and that is that this is all a matrix-like simulation, and in the real world, Hillary Clinton's shortlist for the 6th Democratic appointment to the U.S. Supreme Court is as follows. That is, well, that's my hope. In terms of what is going to be talked about, we've kind of reoriented things a little bit. Our hope is to cover both the major developments of the past term, of course, and also to talk about the implications of the Kennedy retirement and the appointment of a new justice for each of the areas of the law that we're going to talk about. And in addition, we've decided to kind of allocate more time for questions so that we can cover a lot of those sorts of issues outside the context of any individual case. And so we're going to start it off with what I think everyone agreed was maybe the major case of the term, the travel ban 3.0. And to talk to us about that is Shoba Wadhia, who is the director of the Center for Immigrant Rights Clinic at Penn Law School.
Thank you for the introduction. I am in State College at Penn State University Park, so any Penn State alums in the room, a double welcome to you. I'm deeply honored to be here, and I really come to the table as an immigration lawyer and professor, and quite frankly, because I also love the immigration statute. I am here, as was just mentioned, to talk about the travel ban, or Trump v. Hawaii, and I will hopefully end with some good news and a good case. So on June 26th, the Supreme Court issued a 5-4 decision. Chief Justice Roberts wrote it. There were 2 concurrences, 2 dissents, reversed and remanded. The proclamation, or travel ban 3.0, was upheld as the law of the land. How did we get here? There is a less than linear litigation history that began in the Hawaii and Maryland courts, were appealed to the appellate courts, and even before the appellate courts made a decision, the U.S. Supreme Court on December 4th, 2017, strangely issued an order that reinstated the entirety of Travel Ban 3.0 until and unless a different decision was made by the High Court. And so in this way, we already know how the travel ban is playing out on the ground and devastating families and communities each and every day. This is the 3rd version of a travel ban. The first 2 issued as executive orders, this last one as a proclamation. So a little bit of background on the statute. The Immigration and Nationality Act was passed by Congress in 1952. It has been compared second in complication to the U.S. tax code. There are 2 sections in the statute that are relevant to the statutory arguments in Trump v. Hawaii. The first section is 1182F, and it authorizes the president to suspend the entry of, quote, any alien or class of aliens if such entry would be detrimental to the interests of the United States. The second relevant statutory section in the INA is 1152A. This is a non-discrimination clause. It was created by Congress in 1965, the same year that national origin quotas were dismantled. That non-discrimination clause says that there shall be no preference or priority based on race, place of birth, and so on in the issuance of immigrant visas, end quote. And so on the statutory arguments, Justice Roberts found the following. First, 1182F, the suspension clause, is super broad. And so the president is well within his authority in issuing this proclamation just looking at the text of 1182F. Another thing he found is that it's perfectly fine for the president to supplement the immigration statute. This proclamation doesn't supplant it. The counter-argument, which is also my view, is that the president far exceeded his authority under 1182F. If you look at previous uses of 1182F, they were far more catered. Moreover, it really does supplant the INA. If you look at the labyrinth of the immigration statute, we have a network of inadmissibility grounds, for example, that consular officers look at every single day when they're individually vetting individuals and deciding, should someone be issued a visa? Is this person admissible? And so to exclude nationals from whole countries based solely on where they're from, to me, that is supplanting the INA. A second thing that Justice Roberts found is that 212F, or the proclamation, is not cabined by this non-discrimination clause at 1152A. And I was actually struck by how little time and attention this analysis was given in the opinion itself, because to me, this was a very strong and important analysis. First, looking at the legislative history behind getting rid of national origin quotas, and looking at this explicit statute, right? We have to look at the statute as a whole. We have to have some type of harmonization principle when we're looking at one section and seeking to harmonize it with another. And for me, there was a true clash between 1182F and the proclamation, as well as 1152A. But here, Justice Roberts said, there is no conflict, and here's why. Looking at the language of the non-discrimination clause, the language pertains to the issuance of visas. That's very different from admissibility or whether someone can suspend entry. It's apples and oranges. So that was the analysis of the majority court. My own opinion is that it's a distinction with no difference. In fact, the administration actually said for anybody covered by the proclamation, we are going to refuse visas. That is exactly what was happening. When somebody is excluded from the country, they are being denied visas. So I was pretty heartbroken in the way that statutory analysis came through, and the way the legislative history, quite frankly, behind the 1965 amendments were rejected. There was, of course, an analysis made around the constitutional arguments, and Justice Roberts found that even on those grounds, the plaintiffs were unlikely to prevail. And he applied a somewhat novel principle to this case, a rational basis test, and found that the proclamation has a legitimate national security purpose. And the way that he showcased that was to show that, look, Chad, Iraq, Sudan, they've been taken off the list. Look again. There are exemptions here in the proclamation. And look no more. There are waivers embedded. So these are three examples that Justice Roberts used to say that these are, in fact, legitimate national security grounds. He was willing to, in fact, take into account the extrinsic evidence, also known as the president's statements, and the text of the proclamation, plus the presidential authority under 212F to reach his conclusion. So there were two concurrences. Justice Kennedy made a concurrence. I believe in deference. President, behave nicely, right? Justice Thomas also issued a concurrence. We need to question these injunctions. And by the way, we don't even need 1182F. There is inherent authority that the president has to issue a proclamation like the one before us. Justice Breyer issued a dissent and really focused on the exemptions and waivers. And he was pretty thoughtful and civil, the way Justice Kennedy might have liked, in how he carried out his argument. He said, look, if in fact these exemptions and waivers are working, then this might be a lawful proclamation. On the other hand, if there is a suggestion or evidence that the exemptions and the waivers in the proclamation are not working, well, that's when it starts to smell more like a Muslim ban. And then he went on to offer some of the data points, as well as the example he used during the oral arguments, a 10-year-old girl with cerebral palsy who was denied a waiver when she sought one. And what am I talking about when I talk about waivers? Essentially, the proclamation has a scheme that says if you are covered by the ban, if you are not exempt, you may demonstrate eligibility for a waiver and still be admitted on a visa if you can show undue hardship if you're denied entry, that your entry is in the national interest, and that there is no national security concern. So those were the three threshold criterion that were in the waiver scheme. And I have to say that I find the waiver scheme itself a clash with the immigration statute. Congress has already written an elaborate form of what waivers look like statutorily, and here the president has come in to create a new standard that applies to people who are otherwise covered by the ban. And then, of course, Justice Sotomayor's dissent, which also received quite a bit of media airtime, was strong. She found animus and a violation of the Establishment Clause of the US Constitution. She gave a lot more airtime to the statements that were made by the president, both pre and post inauguration. And she was a little critical about the majority's rejection and overruling of Korematsu, and at the same time replacing one bad decision with another, in this case, Trump v. Hawaii. So what do we do now, right? The only game in town for practitioners is to have a meaningful waiver process, right? And to ensure that the waivers are actually working, and to make sure that our communities have accurate information about what is contained in the proclamation. So the next order of business is going to be community forums, know your rights workshops, and information sessions with affected communities and family members. And like with many, this ban is personal, and this is something I've been working on since 4:30 p.m. on January 27th, 2017, when we got our very first ban. It is exhausting, but this is a very long road. And we were just told by the court, who failed us, that this road is even longer than we imagined. So I'm ordinarily a pretty optimistic person, and I want to end, or at least share one other case with you that got very little attention, but was actually a really positive case in the immigration space. I told you I love the immigration statute, so I get to talk about that again. Pereira v. Sessions, and it was a decision that was issued an 8-to-1 majority. And the question in that case is, if there is a notice to appear served on a non-citizen that lacks a date or a time, is it sufficient to meet the stop time rule for purposes of cancellation of removal? WOA, that's a lot of terminology, right? So let me define a few terms here. Notice to appear. This is the charging document that immigration uses to put somebody in the system. And so notice is given by serving the individual with the notice to appear. And once that document is filed with the immigration court, removal or deportation proceedings are triggered. So this notice to appear is not a ministerial document. It's very important. It includes information like, you are from this country, you entered on this date and time, you are alleged to be inadmissible or deportable for the following reasons. You should come to York Immigration Court, which is easy to do since it's an all-detained docket, at 8:30 in the morning on July 20th. So what happens when the notice to appear lacks the time or the date? Well, Justice Sotomayor wrote this majority opinion, 8-1, and said a notice to appear that lacks a time or date is not a notice to appear. And so it's really putting the agency on notice to stop issuing defective notices to appear. It may sound so obvious, right, to any of us who think about basic procedural due process, but this is where it's an awakening, right? That in the immigration space, we've been living with defective notices for many years, but it's now gotten the limelight and attention that it deserves. And why does this matter to the immigrant? Cancellation of removal is one remedy in the immigration statute that if you've acquired 10 years of physical presence and meet other criterion, you can receive protection called cancellation. And so if you're served with the notice to appear, the clock on the 10-year physical presence stops. So that's what makes it really significant to say an undated notice to appear doesn't count. So let me end, since my time is up. I'm not a Justice Kennedy expert, but in the concurrence to Pereira v. Sessions, he actually criticized the courts for being reflexive over Chevron deference. So it's really a tale of two concurrences if you look at Trump v. Hawaii and Pereira. One is sort of, I'm out of here, deference matters, and be nice. And the other was, we really need to pay attention to our intentionality and our deliberate process when we engage in a Chevron analysis. And then truly, finally, because my other area of research is around the role of discretion in immigration, and particularly prosecutorial discretion, we owe a lot of credit and leadership to Justice Kennedy in his opinion in Arizona v. United States. One of the seminal passages in that decision is that as an initial matter, the federal agency has to make a decision about whether to pursue removal at all. And this is an act of prosecutorial discretion that has now been reinforced by the justice. Thank you for your time, and I look forward to your questions.
So before we move on, before we do move on to another topic, I would love to get folks' reaction to the question of, what does a tweet by the president actually mean in the context of reviewing executive action? I mean, can this guy say just whatever he wants to his base, and then the White House counsel's office can just lawyer up and write something? Is the upshot of the court's decision that we're just never going to pay attention to that, or is it limited to this very narrow context of national security? What is the relationship between what the president is saying and the administration is doing in terms of us looking at motivation, whether it's religious animus or something else?
I'll take a stab.
Yeah.
So I agreed with the ruling. I disagree with the travel ban as a matter of policy. Simply because, and this is where it's different from Pereira and other immigration cases, because there's a difference over discretion or deference over national security versus domestic affairs. But to your question, Tom, Roberts, in his majority opinion, went through various statements and said that this, is not good. But at the end of the day, because there were other reasons and the countries only had 8% of the world's Muslim population, and yada yada, the waiver program and all the rest of it, narrowing, carve out, we're talking about 3.0 rather than 1.0, the Stephen Miller special and all that. So it's not that you can do anything as long as it's properly lawyered up and has some whereas clauses or what have you. But given the strong deference, he used the phrase rational basis, which I think is inapt in the national security space. I would have rather preferred just some other kind of discussion, but it's not complete deference, but it's kind of a smell test, and does the rest of the document really line up with something that's isn't so biased?
And the view is this passed the smell test.
Yeah.
Yeah. Okay.
3.0. Remember, this is 3.0, not 1.0.
No, I know, but when you say 1.0, 2.0, and 3.0, they're all of the same thing, right? Are they, like if I get iOS 3.0, it's still for my iPhone. I just wonder if at what point do you think doctrinally, or with what the Supreme Court is saying, enough times this thing gets laundered through, or we fundamentally believe that something different is going on?
Well, I mean, if he stuck to the countries that Obama had identified as national security risks, there was partially by the courts, including the Supreme Court, and partially through the 2.0, 3.0 process. There were exemptions for people with green cards and familial ties and all the rest of it. I wonder how the course of litigation and political discourse, for that matter, had gone if they had forgotten the Steve Miller step and gone straight to the interagency process and the lawyering up, and we hadn't seen a proclamation until several months into the administration. I think the course of litigation would have been different. We might have had more Kagan-Breyer type opinions rather than the judicial resistance on the Sotomayor side.
So just a very brief response to that. Where I stand is that I think this case should have been rejected on the statute, and doctrinally I think there are a number of very clear arguments to support that. And with respect to exemptions and waivers, since I had already reached my 10 minutes, those are problematic, right, for a few reasons. First, we already have a statute that includes waivers, and we already have a framework for our immigration law that Congress wrote in 1952. And to the waivers, and Justice Breyer brought this up both in his oral argument, during the oral argument, as well as in his dissent, there's very little evidence to show that they're actually working. And so even one sworn affidavit by a consular officer that was cited to by Justice Breyer called the waiver process window dressing, and that consular officers actually don't have discretion. And so to the extent that exemptions and waivers were relied upon by the majority to support the legality of this proclamation, I think that alone is problematic.
Well, one of the good things about the term is that we had another opportunity in the form of another case to take a look at these questions of how much scrutiny the court was going to give to allegations of improper motive when it came to religion. We had, in the context of Masterpiece Cake, a not entirely dissimilar case, and so maybe Ria Tabacco can talk to us about that. Ria is a senior staff attorney with ACLU focusing on LGBT issues.
Thank you, Tom, and I'm glad that you made that comparison so explicitly. That saves me 30 seconds out of my 10 minutes not to have to draw the comparison. So I think folks know by now the court in Masterpiece Cake Shop ruled in favor of a bakery that had refused to sell a cake to Dave Mullins and Charlie Craig for their wedding reception simply because they are a same-sex couple. And it did so based on sort of these peculiar facts in the history of the way the State Civil Rights Commission had handled this complaint. I think, I'll say at the outset, I think Pete Williams characterized this ruling as a ticket good for one ride only. And I think it's a really helpful way of understanding how narrow the holding itself actually is. Because, of course, in the process of doing this, the court had process concerns about what the Civil Rights Commission did. But it also said, as a general matter, right, religious objections to a generally applicable and neutral law don't mean you can violate it. We know that. That's Employment Division versus Smith. And that's true in the context of anti-discrimination laws. And that's true in the context of anti-discrimination laws that protect people who are LGBT. So at the end of the day, every business in Colorado, including Masterpiece Cake Shop, right, still has to follow the norm that a business open to the public has to serve everyone. This really is a ticket for one complaint only. So what was the problem in the process, right? And this is where I think many commentators have drawn comparisons to the court's opinion in the Muslim ban case, because essentially the core irregularity, if you'll have it, or the core piece of evidence the court relied on to find anti-religious bias was a statement by one of the civil rights commissioners that essentially said that it is a despicable thing that religious rhetoric has been used in time to justify atrocities, including the Holocaust and slavery. Of course, that is a factually accurate statement. It's also not the same as calling religion itself despicable, right? In fact, in many ways, it upholds the dignity of religion by saying what is despicable is attempting to use faith as a sword in this way. I think putting that comment in perspective makes the comparison between the Muslim ban decision even more stark, because when it comes to the Muslim ban, we're talking about tweets and statements from the person who was the sole decider. And in the case of the Civil Rights Commission, not only was the commissioner one of a 7-member commission, but essentially her comments came so late in the process they could not have affected the decision. So this was an administrative complaint that was originally filed by our clients. It was investigated by the State Civil Rights Division, which found probable cause to proceed. It was then adjudicated by an ALJ, who granted summary judgment in favor of the state and our clients. It was then appealed to the full 7-member commission, which affirmed after a public hearing. And it was then, in the context of the bakery's motion to stay the remedial order, which required them to treat everyone equally, kind of the motion to stay that remedial order that this comment was made. And so clearly the comment is made after the substantive decision had been made, in a context where all of the substantive decision making had happened in public, and so there's no chance, as some people have suggested to me after the fact, that somehow this bias might have infected an earlier part of the decision-making process, or there may have been secret deliberations. The commission's deliberations are public. We have a transcript. They're in the joint appendix. And so we know that this was the first time that anything that troubled the court really was said. And I think that step in the process obviously contrasts in a very dramatic way to the court's willingness to overlook explicit statements of anti-religious bias by the person who was, in fact, the decider. So all of this means, I think, that the ruling in Masterpiece Cake Shop itself is quite narrow. But the decision, of course, is going to reverberate, both for what it says and also for what it does not say. One of the most interesting things about the opinion is that, at the start of the term, this case had been expected to be a blockbuster free speech decision, whatever the outcome. And I think many folks thought that's how it would be decided. Because, of course, the bakery had said that essentially because the product that it sells is artistic, which itself was a question to be decided, is a wedding cake artistic? But let's assume for the moment that it is. So because the product it sells is artistic, and art, we all know, is protected by the First Amendment, that means that free speech somehow justifies its decision to turn away same-sex couples in violation of Colorado's Anti-Discrimination Act. And that actually is the claim that the Trump administration weighed in favor of. The Solicitor General filed an amicus brief in support of the bakery, addressing only the free speech question and not even touching the free exercise question, which was how the court ultimately decided it, which I think also was a signal or some indication of the weakness the administration saw in the free exercise claims after Smith. It's hard to see how you get out of complying with an anti-discrimination law, particularly because the court had already rejected requests for exemptions in the context of race discrimination, and in fact in sex discrimination as well. Unless you're willing to say there's something different about sexual orientation discrimination, which of course we know from Kennedy's jurisprudence, he's deeply disturbed by the notion of a government that creates a second-class citizenship for people who are LGBT. So the speech claim, really not engaged with at all, but the court does sort of lay out two guideposts that I think are helpful in how it was thinking about speech, and both of which, by the way, I agree with. One is simply that the refusal to sell any cake at all is not protected by the First Amendment because it has nothing to do with the artistry. And of course, that's the facts of this case, right? Dave Mullins and Charlie Craig walked into the store. They were turned away essentially right away. No discussion of what cake they might have wanted. And in fact, in the record, we had evidence the bakery had refused to sell even cupcakes for a lesbian couple's commitment ceremonies. There's no question this refusal was not about artistry. Then at the other end of the spectrum, the court says, well, if the commission had required them to write a specific inscription on the cake, that might raise First Amendment questions. And I think that's true as well, right? Of course, the Anti-Discrimination Act is not about expression, it's about people. If the state were to pass a law that said, all bakers must produce cakes that say MAGA, right? Now we start to see something that looks like a law that targets expression. And of course, this law did no such thing. And those are the guideposts the court set out. Those, of course, become highly relevant because this is not the only context in which our opposition is seeking exemptions from anti-discrimination laws. And we know that the same lawyers representing the bakery represent a flower shop in Washington State in the Orleans Flowers case, but also represent an employer who alleges that it is entitled to fire a woman because she's transgender. Because of religious beliefs. They're also using requests for exemptions as an attempt to exclude transgender people from public places like restrooms and locker rooms. So this is not about wedding-related services, right? This is about a barefaced denial to relegate LGBT people to second status. And that's something I think the opinion very firmly rejects. And that, I think, is actually what it will be cited more for going forward. When we look at the court's LGBT docket in the coming term, the court GVR'd or granted, vacated, and remanded in the Orleans Flower Shop case, which, of course, is essentially identical to Masterpiece Cake Shop, except for the fact that there is no evidence at all of hostility by the state. Whatever you make of the Colorado Commissioner's statement and whether or not you think it evinces hostility, certainly it's something, it's there. There is no there in Orleans Flowers, and in fact, there was no state administrative process at all. The case was initiated in the Washington state court system. So unless the court is willing to say that the Washington state courts have somehow demonstrated hostility to religion, at base what you have is the argument that simply the decision to enforce a civil rights law against someone who has chosen to violate it because of their religious beliefs is itself somehow hostility to religion. And that, of course, I think really butts up in a very direct way against Employment Division versus Smith. And I don't see a lot of appetite in the court to overrule that. Of course, Justice Kennedy has been a tremendous champion of LGBT equality. It doesn't need to be said in this room that he has been at the forefront of the court's trajectory in recognizing the equal dignity and really the common humanity of what it means to be LGBT. And of course, from that perspective, it is devastating to lose him on the court. I do think that his journey reflects a journey that our nation has made over the past several years and perhaps decades towards recognizing what it means to be LGBT, what it means to be gay and lesbian, and what it means to be transgender. And those advances, of course, are not erased by his departure from the court. In some sense, in the very next term, I think the next issue to reach the court will not be one of constitutional magnitude, which of course is where Kennedy had made his mark, but actually in the statutory context. And that is raised by the fact that only the federal government and 60% of states still don't have laws that expressly prohibit discrimination based on sexual orientation and gender identity of the kind that Colorado does, which was at issue in Masterpiece Cake Shop. What we do have is laws that prohibit discrimination based on sex. And so there's been a growing consensus among the courts that sex discrimination includes discrimination against somebody because of their sexual orientation or because of their gender identity. This question comes up in the Title VII context in employment discrimination and also in the Title IX context when it comes to schools that have attempted to exclude students who are transgender from restrooms and locker rooms that other students use. And so there are at least 2 or 3 petitions. 2 have already been filed in the Title VII context. One out of a Second Circuit decision finding that Title VII does cover sexual orientation discrimination. Another, an 11th Circuit case finding that Title VII does not cover sexual orientation discrimination. Those petitions are now being briefed, presumably will be so over the summer. We are also expecting a petition filed in our case, EEOC versus Harris Funeral Homes, where we represent the intervening complainant, Amy Stevens, who was fired for being transgender. And we won in the Sixth Circuit below with a decision that sort of combined these two issues and said both that transgender people, like everyone, are protected from sex discrimination under Title VII, and also that RFRA, the Religious Freedom Restoration Act, doesn't provide a defense to the anti-discrimination provisions of Title VII. And when it comes to statutory interpretation of Title VII, I don't know that Justice Kennedy actually was very much differently situated from other justices, and in many ways, the most important precedent on point is on Call versus Sundowner Offshore Services, a unanimous court with an opinion from Scalia finding that the sex discrimination provision in Title VII prohibits all forms of sex discrimination, regardless of whether or not that was what the legislature intended when they passed the statute. And that, of course, is one of the key decisions that lower courts have relied on in finding that sexual orientation and gender identity are covered. So I think when it comes to that question, there are certainly other justices in play. I think the Chief may be in play. And certainly there has been a growing consensus, not merely from liberal judges, just that this form of discrimination is prohibited.
Tremendous, thank you. So the discussion of discrimination against transgendered individuals in employment is a natural transition to labor and employment questions at the court. Ben Sachs is a professor at Harvard who focuses on these sorts of issues. We had two major cases this term, and you may even want to talk about those issues that are coming up.
Yeah. So I'm also an optimistic person by nature, but if you had to imagine a way of dismantling the ability of working people to demand and exercise rights, you might imagine a case called Epic Systems and one called Janus versus AFSCME, and we had both of them this term. So Epic Systems, as everybody knows, is about arbitration. And the question in Epic Systems is whether an employer can require employees as a condition of employment to resolve all claims against their employer, one, through arbitration, and two, as an individual. And what the court says, using what had been a relatively obscure statute that was meant to deal with arbitration between two businesses, what the court says is, yes, employers can require employees as a condition of employment to do that. And if there's a contract to that effect, it has to be enforced. Given the small dollar value of many workplace claims, this means that workers will just have no way of enforcing many employment rights unless something changes. The specific legal issue in Epic Systems was whether such a contract requiring individual arbitration was inconsistent with the National Labor Relations Act, which is our federal labor law. Why might it be inconsistent? Well, federal labor law says that everybody has the right to engage in concerted activity for mutual aid and protection. That concerted activity includes traditional union organizing and collective bargaining, but it also involves what the statute calls other concerted activities for other mutual aid and protection. And the National Labor Relations Board and the United States Supreme Court had long understood other concerted activities for mutual aid and protection to include concerted legal action. And so if you have a contract that says to workers, you have to pursue every legal claim against me, the employer, as an individual, that's asking the employee to waive their National Labor Relations Act right to engage in concerted activity. And even the Federal Arbitration Act says, we don't enforce arbitration agreements that are themselves illegal. And so the National Labor Relations Board had said, this kind of contract is like what used to be called a yellow dog contract, which was a contract that said, I agree as a condition of employment never to join a union. Those are illegal contracts. And because the right to engage in concerted legal action had the same footing as the right to join a union, these arbitration clauses were illegal and not enforceable even under the terms of the Federal Arbitration Act. The Supreme Court, of course, rejected that, and it did so in a way that's exceedingly damaging. And I'll say two things about that. One, the bare holding. So the holding says that now not only can class action waivers be enforced and arbitration agreements be enforced in the consumer context, which we know from Italian Colors and Concepcion, they can also be enforced in the employment context. And we're seeing an explosion of these things already. They were on the rise, now they're exploding. And so most workers, I think, very soon will be subject to individual arbitration whenever they want to pursue any claim against their employer. That's horrific from the perspective of workers' rights. The other thing that Epic Systems does that's very damaging is less prominent, but important. The way the court reaches its holding is to say there's no National Labor Relations Act problem with a class action waiver in a mandatory arbitration agreement in an employment contract. There's no National Labor Relations Act problem because the National Labor Relations Act doesn't, in fact, protect your right to engage in concerted legal activity. What the National Labor Relations Act is about, says the Epic Systems Court, is traditional union organizing and collective bargaining. Now, why is that a problem? That's a problem because a lot of workers today don't have the opportunity to engage in traditional union organizing and collective bargaining. The hope for the labor movement is in this other concerted activity stuff, right? Online organizing, Facebook organizing, worker centers, novel forms of collective activity. And what the court is doing, although it hasn't gotten there yet, but what the court is doing in Epic Systems is it's laying the groundwork for a move in the direction of saying that the federal labor law only protects traditional labor organizing and collective bargaining. That is to say, it only protects the thing you can't do anymore. The thing you're trying to do, right, that's not protected. Okay, so that's Epic Systems. Then on the last day of the term, we have Janus versus AFSCME. There's, everybody knows what this case is about. The question is, can public sector unions require employees who are covered by a collective bargaining agreement to pay a fair share fee for the representation they receive from the union? Why is this important? Unions, as a matter of law, must represent every worker in a bargaining unit equally, whether or not that worker decides to become a member of the union. So when the union negotiates pay increases or benefits increases or just cause dismissal policies, when the union does grievance representation or arbitration representation, the union has to provide those services to workers irrespective of whether the worker joins the union as a member. Unless there's some way for the union to require workers to pay for that, we have what Justice Kagan calls a collective action problem of nightmarish proportions. Okay? Imagine, as an analogy, the US government decides that taxes are voluntary. Okay? So now, you know as a citizen that whether or not you pay $1 in taxes, you get the same roads, the same schools, the same police and fire protection, the same military, right? And it's just up to you, pay or not. Now, I don't know what anyone in particular in this room would do, but I hazard to say that fewer people would pay their taxes. That's the situation that's now been foisted onto public sector unions by the Supreme Court. Everybody, every public sector worker represented by a union has the right to receive every ounce of union representation and to do that without paying a single penny. That's very difficult to sustain, right? And I think that we're in for a period of severe challenge for public sector unions and therefore for public sector employees. I haven't mentioned much about the doctrine. I'm not sure this case is about doctrine, to be perfectly honest. I liked President Trump's tweet about Janus, the moment it was decided, he said, "This will be tough on the Democratic Party's coffers." That, of course, is true. Public sector unions are a way for working people to aggregate their political voice, and they've done so, and now they're going to have a much more difficult time doing that. All right, I said I was an optimist. I know I'm out of time. There is a bill in Congress that would help deal with epic systems. It would make illegal the kinds of class action waivers and employment arbitration agreements that are so damaging to employees' ability to assert their rights. What do we do about Janus? The bad news about Janus is that it's a constitutional holding, it's a First Amendment holding, so there's nothing directly that Congress or state governments can do about the holding. But there are ways that states, and I'd be happy to talk about this more, there are ways that states can amend their public sector labor laws that would enable unions to find other ways of financing themselves. On Justice Kennedy. Justice Kennedy has not been as good a friend of workers and unions as he has been of the LGBT movement and community. I don't think that means that things won't get worse. And I think that, just to take Janus and the union context, there are more steps that I think we need to be concerned about. So Janus is a holding that fair share fees are compelled speech that is unconstitutional under the First Amendment. There are cases now pending all over the place that challenge the very idea of exclusive representation as compelled association unconstitutional under the First Amendment. So exclusive representation is just the system of union bargaining that we've had since 1935. It just means if 51% or more of workers in a unit vote for a union, everybody's covered by the union and by the contract. Okay? That is now susceptible to attack under the First Amendment. Another problem.
Yeah, Ben, can I just ask, is that true both in the public and private context, or is that still very much focused in the public?
Okay, great. So another problem is Janus applies to the public sector because it's a constitutional holding. I think there will be an effort to export Janus to the private sector. That will happen through in Congress, but it will also happen in the courts. And you might think that's crazy because we have something called the state action requirement, and there's no state action when a private sector union and a private sector employer decide to negotiate a collective bargaining agreement. I'm more worried about the prospect for erosion of the state action doctrine exclusively in the union context with a fifth justice who replaces Justice Kennedy. So we may see a constitutional attack on exclusive representation and exporting of both the agency fee and the exclusive representation rule from the public to the private sector. And then, in some ways more narrow, but also terribly devastating, there are breadcrumbs in the Janus opinion about what you might think of as a retroactivity problem. So Justice Alito has a number of lines in which he talks about how many, I think he uses the phrase, billions of dollars in agency fees have been extracted from members unconstitutionally over the last number of years. I don't know why that's in there, but Justice Alito set up Janus in a case called Knox, where he very skillfully plants seeds that he then harvests years later. And I think what's happening in Janus potentially is a signal that unions should be on the hook for fees that have been paid and, of course, spent over the last handful of years. So, and my sense is these kind of more ambitious jurisprudential moves might be more comfortable for the justice that replaces Kennedy than they would have been for Kennedy himself.
Thanks so much.
Can I reply?
Yeah, exactly. So Ilya Shapiro, who's a senior fellow at Cato and is the editor-in-chief of their Supreme Court review, do you have thoughts about this?
Yeah, I sort of feel like whatever the opposite of a skunk at a garden party is, a Cheshire cat at a wake, I'm not sure. The only major case I disagreed with this year was Wayfair, the internet sales tax, physical property taxation case. We can talk about that if you want. I'm a fan of the Dormant Commerce Clause, the only thing that I've identified in which I disagree with Justice Gorsuch. But regardless, on Janus, I think to understand this case, we have to differentiate and understand the difference between the interests of workers and the interests of unions and the public versus the private sector. This is why I think we will agree as advocates if this is exported to the private sector. So first of all, this case was not brought by the Chamber of Commerce or a collection of companies or anyone standing in for those kind of interests. It was brought by a worker. And the previous one, 4 years ago, the Fredrickson case that ended up deadlocked 4-4, was brought by a teacher in the public sector, claiming two things. First, I don't like what this union is collective bargaining for me. Forget free riding. I'm a forced rider. I'm forced to pay for, merit pay rather than seniority protections, or vice versa. I don't want this. And as Justice Alito correctly pointed out, we can't even compel private sector organizations. And remember, unions are supposed to be not the government, even in the public sector. I know it's a legal fiction, especially in places like California that try to have union-state collusion very closely. But we don't allow compulsion of people to pay for stuff they don't want, other than taxes, because that's the government acting directly, and that's a different case. But unions can't do that. And so even if we agree, that would be a problem. But moreover, the broader problem in the public sector, which does not exist in the private sector, is that inherently everything the union does, including the collective bargaining component, has salience in public policy. So not just the electioneering, but also state budgets and education policy, transportation policy, contracting. Everything that the union does in the public sector has public policy salience, and that's why this is very different. And if the interest is labor peace, there are more narrower ways of achieving that. You don't need to compel these fees. And we've seen that in the 28 states that don't have these kinds of agency fee arrangements. There, unions haven't completely disappeared, but they've been forced to become efficient and effective and actually responsive to worker concerns rather than getting involved in larger national issues that are unrelated to employer-employee relationships. So while it's absolutely true that this will be detrimental to union coffers and Democratic Party coffers, that's, as Justice Alito pointed out in replying to Justice Kagan's dissent, is not a legally cognizable reliance interest for the purpose of looking at stare decisis. And I think this stare decisis aspect of this case is just as important, or more important from a legal perspective, forgetting the practical side, as anything else. Just like John Roberts' concurrence in Citizens United focused on stare decisis is a key part of that decision. So that's, I guess, what I want to say about Janus. And the other case that I...
Can I stop you? Because stare decisis now takes on an even greater role as we think about where the court might go from here. What do you take away from Janus about the current court majority's willingness to revisit kind of Warren Court era, early Burger Court decisions that are treated by some as kind of bedrocks of civil liberties, the rights of criminal defendants, things like that?
Well, I think we have to cabinet Roe v. Wade. It's kind of its own category. When we talk about more sort of run-of-the-mill type of precedents, it really depends. Is it working? What is the quality of the reasoning there? Is it just made up out of thin air, or does it follow from kind of the way the law had been developing? Is there actual legal reliance? Have people structured their businesses, their lives, what have you, around the rules that the court established in the same way that Chief Justice Rehnquist in his time declined to overturn Miranda? I think certainly Chief Justice Roberts is very much into not making waves unless that's absolutely necessary, and so he's, I would like the court to overturn more bad precedents. I'm sort of more with Thomas on certain things in that regard, but I wouldn't worry about the quote unquote super duper precedents, but I think we could see reconsideration of Quill that was overturned in Wayfair was also a pretty big deal. So setting aside the huge culture war sort of things, maybe we'll see.
Okay. And I interrupted you. Was there something you were going to say about that?
A case that I don't know if anyone else is going to mention, Murphy, that I wanted to highlight versus NCAA. You can bet that this is going to have major ramifications. This is about sports gambling and about federalism more than that. The point here was Congress was trying to use the states to regulate sports gambling. And going back to an area of law that the court hadn't seen in about 20 years, the anti-commandeering doctrine, the court majority, 7 justices, said, no, you can't do that. The 2 others didn't say, yes, you can. They simply said, we could have interpreted the statute in a way to avoid the constitutional problem. But that's important because I'm sure as folks in this room are increasingly becoming fans of federalism, I think that's a healthy thing. And the only way that we can diffuse tensions in Washington is to push down decision-making as much as possible. So whether you're talking...
Do you want to just take a second and explain exactly what the statute did, how
sure.
it was supposed to
Yeah. So Congress said that states cannot facilitate gambling, sports gambling. And New Jersey wanted to repeal its restrictions and impose certain regulations to create a market to allow for sports gambling. There was a vigorous debate about this, and
I laughed.
Tom's a big gambler, so I know he's very curious about this. And the court basically said, look, we leave it as an open question about whether Congress itself could regulate or criminalize gambling in the states. That's an open Commerce Clause question, I suppose. But Congress can't do a workaround and use the states to do what it wants to accomplish. I doubt there's much appetite in Congress to pass a broad new criminalization or what have you. And so much as in Wayfair has opened up opportunities for states to have different taxation regimes, I think we'll see different experiments with different states opening up sports gambling in various ways. And there will be litigation over, well, what happens if you're placing bets on an out-of-state team versus an in-state team, or these kind of cross-border sorts of things. But it's not very often that the court legalizes something that has been closed off. And so we're sort of a bit in the true laboratories of democracy in this area, and hopefully that'll spill over into these other fights over drugs and immigration and guns and whatever else.
All right, tremendous. Thank you so much.
Should I say something about Kennedy? Or
I'm sorry?
Should I say something about Kennedy?
Please.
So Kennedy is... he's the justice I probably most agreed with in result, but was still infuriating in terms of how he got there. It was a bit of a black box. I mean, very good on the First Amendment, probably the biggest defender of the freedom of speech that probably we've ever had, but was a bit of a philosopher king in the sense that he struggled with every case. It's not that he was swinging back and forth at random, but did not fit into conventional jurisprudential modes. And I think that's problematic for the rule of law, because you want consistency. You don't want everyone just aiming their arguments to try to fit into the Equal Dignity Clause or whatever the latest writing that he might have done. And you can't even make blanket statements that he was great on constitutional structure or individual liberty or something like this, things like that. Sure, he had that great concurrence from my perspective on the Commerce Clause in a case like Lopez, and in Bond about federalism and individual rights structure. Federalism protects liberty. But then he also, in Raich, I guess because drug users shouldn't be as respected as the LGBT community, I don't know why, said that the federal government can regulate plants that you grow in your backyard. And in Kelo, said that property rights aren't as important as other kinds of fundamental rights. So, it's, I liked him a lot for many things. I didn't like him for other things. He was frustrating. Going forward, I will adopt the line that Jan Crawford used at CBS News, that it was the Democrats' biggest political blunder to use the filibuster against Gorsuch, because now they can't use it in a place where it actually matters, where Gorsuch for Scalia was like for like. Now it's moving the court more to the right. One thing we do know is that we're not going to get a Trumpy judge, meaning I don't think we're going to have Chris Christie or Rudy Giuliani, Judge Judy. I mean, who knows? Jeannie Pirro. I mean, who knows? I mean, he's going to go from the list, and that list would have been no different if Ted Cruz had been president or anyone else. So I'll be looking for different things than y'all are. I mean, I differentiate the various people on his list of 25, but I'm optimistic about that. But it's going to be a very, very different court, not just in terms of left-right, but in terms of the Chief Justice being the median justice. We haven't had that in a very long time.
Yeah, I didn't really have the understanding that you did that the filibuster of Gorsuch accomplished a lot. But Rick, do you want to take us into another area that we had thought of Justice Kennedy as being incredibly important?
Sure.
Rick is at UC Irvine and is one of the nation's leading experts on voting, campaign finance, elections, and the like.
So I'm a pessimist by nature, but I've become much more pessimistic over the last term and the last few days. What I was going to say until yesterday was that there were 3 significant election law cases of the term. 2 were conservative victories and 1 was a punt. But I now think we had 3 conservative victories, looking at it in hindsight. The most important of these cases, by far, was Gill versus Whitford, which was the partisan gerrymandering case out of Wisconsin. There was a second case that was granted, Benesek, which was a case out of Maryland, which involved Democrats engaged in partisan gerrymandering. Kind of a mystery why they took that. But the main action was the Gill case. The question was whether or not there were judicially manageable limits to separate permissible from impermissible consideration of party when you draw district lines. It's sometimes said that gerrymandering has become so effective now that legislators choose their voters rather than the other way around. And we have to go back 14 years to a case called Veith, where the Supreme Court first, well, I don't say first, but addressed this issue in the most significant way. And there the court divided 4-1-4. There were 4 justices led by Justice Scalia who said this is none of the court's business. This is a non-justiciable political question. There are no standards. Then there were 4 liberal justices who said there are standards and in fact came up with 4 different standards, I think, as a way of doing a kind of beauty pageant for the justice in the middle, who was Justice Kennedy. Justice Kennedy said, I agree with the liberals, let's keep the courthouse door open. I agree with the conservatives, all these standards are bad. Keep trying, people. Try the First Amendment. Try looking at history, try looking at computers. And so for the last 14 years, there have been cases that have been trying to please Justice Kennedy. And Gill was the perfectly teed up case because here there was a somewhat new standard for measuring the amount of asymmetry and partisanship in redistricting plans. What was added by taking the Maryland case is that it raised Justice Kennedy's favorite theory in this area, which is that maybe rather than thinking of these as equal protection cases, they're really better thought of as First Amendment cases where someone is being penalized based just on who they are and what they believe, like in the patronage cases where a janitor is fired by the governor because the janitor's a Democrat rather than a Republican. And so everything was teed up, and then Gill was this huge punt where the court came up with an opinion by Chief Justice Roberts that was a punt that decided in very strange ways on standing grounds that rather than addressing the entire state districting plan in Wisconsin, which was alleged to be a Republican gerrymander, you have to go district by district. As a matter of standing law, it was odd, but what was even odder about it was that Chief Justice Roberts said, pay no attention to what's going on in Justice Kagan's concurrence. And Justice Kagan's concurrence was basically the roadmap to here's how you bring the First Amendment claim that Justice Kennedy loves, and isn't it wonderful? And Justice Kennedy was silent. And looking back now, and especially in light of what Justice Kennedy said in his separate concurrence in the travel ban case, which we heard about earlier, which was everyone who's in government has an oath to uphold the Constitution. Be best, as someone tweeted. That was Kennedy's parting message. It seemed to apply in the partisan gerrymandering case, too, where he was not willing to take a side. After 14 years of playing Justice Hamlet, he left the stage without finally making his determination. This means that the next justice to come in is very much likely to be in the Scalia mold. And we know where Scalia and Gorsuch and Thomas and likely Alito and Roberts are going to be, which is that these cases are going to be seen as non-justiciable. That means that the next case that's coming up, that the court, the punt after the punt, which was the North Carolina partisan gerrymandering case, the court could have taken that one for next term. It didn't take it. That's the case where North Carolina, 50-50 state, after the lines were found to be a racial gerrymander, The North Carolina General Assembly drew the lines again. In a 50-50 state, they made 10 of 13 congressional districts majority Republican. When the legislative leader was asked why he did that, he said because he couldn't figure out how to draw an 11th Republican district. This is what's coming. That was one of the 3 cases. That's the punt, right? That's not even the loss. The losses came in one case out of Ohio involving voter purges, a case called Husted versus Philip A. Randolph Institute, and a case out of Texas involving Texas redistricting called Perez versus Abbott. Both of these cases featured a 5-4 conservative liberal, Republican appointed, Democrat appointed split. Both of them featured a very nasty back and forth between Justices Alito and Sotomayor, who I think are now taking the leads in these areas. Both of these cases are cases where you see the conservative majority pulling back on voting rights. The Ohio case is very technical, involving how to read a certain provision of the National Voter Registration Act, the Motor Voter Law of 1993. But the message seemed to be give states their breathing room to pass laws that might make it harder to register and to vote. And in the Texas redistricting case, which I didn't expect was going to be a big deal, half of the opinions were spent on whether or not there was even an issue before the court, because no injunction had been issued by the court, so it was very odd procedurally. But then when the court got to the merits, the court essentially shut down a path that the Supreme Court in the Shelby County case 5 years ago, exactly 5 years ago from the day that that opinion came out, promised, well, if there are bad actors, those bad actors like Texas could be put back under federal supervision for up to 10 years. This is Section 3 of the Voting Rights Act. To do that, you have to show intentional racial discrimination in voting. And what Justice Alito's opinion did in the Texas redistricting case was to say, no, there's not enough proof of intentional racial discrimination in a way that I think is going to make it very difficult to prove it in any case. He said you must presume the good faith of the state when it passes laws. So this is what we're looking at. Okay, after Kennedy. Now, I think the 3 worst election law opinions that the Supreme Court's issued in 2 generations, 2 of them were written by Justice Kennedy, and one of them, Justice Kennedy was in the majority. That's Shelby County, Citizens United, and let's not forget Bush versus Gore. But yet I am lamenting the day that Justice Kennedy retires, because partisan gerrymandering will likely be non-justiciable. The Voting Rights Act, if not completely overturned outright, which is where Justice Thomas is and probably Justice Gorsuch is, it will be left to die cuts by 1,000 deaths. That was certainly the message from the Texas case. There's going to be the courts stepping away from trying to police voter ID laws, where they've kind of tried to take a middle path. I think they're going to be much more likely to go in the Scalia path of saying, if these laws don't burden most people, it doesn't matter that they burden some people. I think we're going to see contribution limitations in campaign finance struck down. So the other part of the McConnell case, the part that the court didn't strike down in Citizens United, the other half will fall. And I expect we're going to see more partisanship on the court. And it's pretty clear now that we not only have a court divided conservative versus liberal, we have a court that is divided Republican appointed versus Democratic appointed. And it's going to be much more common to talk about what the Republican justices did and what the Democratic justices did. And this is going to further undermine, I think, people's faith in the process, especially when opinions are going to come out written by Republican appointed justices that are going to favor the Republican Party when it comes to issues about voting and democracy. I hope I've cheered you all up.
So, Rick, let me just ask about the contributions question. And so we saw in the context of Janus the implication that it would be development in constitutional law that could have partisan political implications. I wonder kind of what in the tea leaves makes you think that this kind of really bright line that has existed in campaign finance law for a while between expenditures going out and buying an ad, which are obviously very significant, and actually contributing to candidates. Your view is that the Supreme Court in the next couple of years is going to say that you have a constitutional right to give an unlimited amount to candidates for office?
I won't predict it with 100%, but I think that's the most likely place to go. And just like we heard about seeds being planted, I think the seeds were planted in the McCutcheon case. And I'd point you to a case that's coming up out of the Ninth Circuit, which no one's paying attention to yet, a case called Lair versus Modal, which is a a case involving Montana's contribution limits, denial of en banc consideration by the Ninth Circuit with a very strong dissent from denial by Judge Ikuda, very well-respected judge. This is going to get a lot of attention. Judge Ikuda basically said, Ninth Circuit's applying the wrong standard. You have to come up with actual evidence of corruption, not a risk of corruption, but actual corruption to justify any contribution limit. That would be a way to basically strike down contribution limits without striking them all down. Just say, we're going to send this back for the development of evidence, and if it doesn't happen, then this particular contribution limit we struck down. Again, death by 1,000 cuts seems to be the median Justice Roberts' favored mode of proceeding in these cases. So I think they're very much in danger.
Okay. Thank you so much. We saved good news for last. So Lenese Herbert is a professor at Howard and is an expert in all manner of issues related to criminal law and criminal justice. And one of the major cases of the term involved the Fourth Amendment.
It did, and thank you for having me here. Thank you all for coming. The Carpenter case. The Carpenter case is commonly known as the GPS cell tower cell phone case. And I say GPS specifically because we are in this post-Jones, post-Riley era of this metadata being collected by sort of these third parties. And the introduction of this era of law came via the Jones case and Riley. Although when you talk about seeds planted, everyone talking about that notion of seeds planted and sort of teeing up sort of cases to come. I remember seeing something like this way back in Quan. And since I'm speaking in front of a progressive group, I'm going to do what we all do, right? I'm going to blame Scalia for all of this. Because back in Quan, Scalia basically, in a concurrence, which sounded like a dissent in some points, which he was wanting to do, he chastised his colleagues for not taking on the technology of the day and sort of deciding each case on these very narrow, specific bases without sort of thinking about the broad general constitutional jurisprudence in the law going forward. But it's funny, when the court finally decided to take on this sort of post-internet, this post-internet era case of Jones being the GPS case, not even 5 minutes, I went back and looked at the timer, not even 5 minutes into the oral argument, what does Scalia do? He basically says, well, listen, I know I'm supposed to be talking about Carpenter, but I'm really going to be talking about Katz. Mm-hmm. He said, I think Katz was wrongly decided. But it's okay, don't worry about it, because we're not going to overrule it today. However, and that struck me, particularly because it seemed to be out of nowhere, this attack. And you want to just
give it 30 seconds on which part of Katz, the holding of Katz that you're talking about?
So the understanding that we sort of operate under in the Fourth Amendment with respect to Katz is this concept of what does the Fourth Amendment protect? And so what happens in Carpenter, which again alarms me a bit. I know I should be optimistic about it, but I actually was alarmed by the dissents and even a little bit of Robert's writing in the majority. This notion that the Fourth Amendment is based, this understanding of privacy and protection, is based on the Fourth Amendment concept of protecting one's person's, houses, papers, effects from unreasonable governmental intrusions via search and seizure. What Katz did was some say augmented, some say added, some say inappropriately expanded. And by inappropriately expanded, even constricting some of the traditional notions of privacy, Katz added a test that basically came from the concurring opinions of Justice Harlan, which says that we've got a two-prong assessment that we're going to make with respect to the Fourth Amendment protections. The first prong is there subjective, i.e. manifestation of an expectation of privacy? And two, is this an expectation that society is prepared to accept as reasonable? And so the question is this notion of this expectation of privacy that it seems that some of the dissenting justices in Carpenter and some of the justices critical of Katz, they seem to have problems with this concept of this reasonable expectation of privacy that's not tied to some common law understanding of property law and property rights. And so to the extent that Scalia seemed troubled by Katz, he said, I'm troubled by it. I think it was wrongly decided, but we're not going to overturn it today. And he said that again at the outset of the oral argument in Jones. And so in Carpenter, we sort of get, so there's Jones, and Jones, of course, gives us this understanding of who we are now in this modern digital age, this notion that and this is not the language the court is using, but there's I'll use the language the court uses, which is essentially you do have a reasonable expectation of privacy in the entirety of one's movements, in the entirety, the whole of one's sort of location, physical location, and to the extent that the government is in fact trying to collect or obtain information about your location, particularly in the case of Jones, this was about 28 days of data that was being sought, then the government is in fact conducting is acting under the Fourth Amendment, and this is a Fourth Amendment implicating activity, and certainly to the extent the government needs a warrant, the government needs a warrant and should in fact have a warrant when engaging. And I hesitate to say what the holdings were, because there was not one particular understanding that came from Jones. There were sort of a majority of 5 that definitely agreed that there was a Fourth Amendment interest in one's whole movements, one's entirety of movements, but they all came down in sort of different little spaces and places under the Fourth Amendment. And again, you see this sort of rearing its head in Carpenter, but not so much. Some of the justices believe that by virtue of attaching a GPS monitor on the vehicle of Jones, that there was a trespass committed, and that under traditional common law property notions was sufficiently problematic for the government. They trespassed to get the information. Others, though, went along with more of the Katz notion, this reasonable expectation of privacy and movement. So there's been discussion in the literature, there's been discussion online, in conferences, about this concept of, do you have a reasonable expectation of privacy in your movements, in your location? Is that something that society is prepared to accept as reasonable, given that we all are giving our information to the cell phone providers and internet providers? And so this brings us up to the Carpenter decision. And Carpenter is particularly interesting because it basically meets us at this intersection of this notion of having some reasonable expectation of privacy in one's entirety of one's movements, the whole of one's movements, but also it butts up against the concept of disclosing one's information, particularly location information, to some third party. That would be the cell providers. There's a doctrine, as many of you know, that basically says you disclose your information to a third party under the Fourth Amendment, you don't have a Fourth Amendment interest in it. And sort of alongside that, and this is the Miller-Smith combination of cases, to the extent that one seeks to claim some sort of Fourth Amendment interest in another entity's business records, here would be the cell provider's records, you don't have a Fourth Amendment interest in the business records of the cell provider. So getting back to Carpenter, because again, this to me was almost a setup, and it seemed to, I know we're in the World Cup time, so I keep trying to use the phrase set piece here, but I don't know enough about soccer to do it correctly. So Carpenter essentially is a case that involved the FBI requesting 4 months worth of location information, cell site location information from Carpenter's cell providers, Mobile PCS and Sprint. And this was done because the FBI had encountered a cooperating, confessing co-conspirator of Carpenter's because they were investigating this string of robberies across Michigan and Ohio of, do you remember this place? Radio Shack and T-Mobile stores. And so this conspirator, who's a cooperating witness who also confessed, a lot of C's there, implicated Carpenter. and gave up Carpenter's phone number. And from this phone number information, the FBI went to the cell providers to get the information, the location data from the cell towers to sort of place Carpenter on, actually in the space and time to sort of prove up the opportunity for him to commit these robberies. And then later, in fact, at trial, there were I think 7 other co-conspirators who actually pointed the finger at Carpenter, saying he was the mastermind. And so the providers turned this over. And this, by the way, was not done via a warrant. It was done by a court order. Pretty much, it seems, a subpoena. And we know we've got different standards, and this is one of the discussions, by the way, in Carpenter, the different antecedent justification that's required for a subpoena as opposed to a warrant. That became a topic of discussion. I won't waste time on it now. But essentially, Carpenter moved to suppress that data at trial, before trial. The trial court denied that motion to suppress. He was convicted basically on 11 charges and sentenced to over 100 years. There were some mandatory minimums involved in that. And so on appeal, Sixth Circuit said, well, you don't have any Fourth Amendment interest in this information. And besides, you turned it over voluntarily. Third-party doctrine, Miller-Smith, governs. So at the Supreme Court, it's very interesting what happened. The court seemed to, it's fascinating in some respects. Roberts wrote the majority opinion, it's 5-4. The court said essentially, listen, this is such a new phenomenon, and we are so dependent on our cell phones. And then talk about, again, seeds being planted. Justice Sotomayor has been doing this for over decisions now. This notion of, and we have the doctrine already of cats and sort of trying to sort of fit this new technology and this new phenomena, this cell site location information into it. She's been saying for a long time, we need these phones. We depend on them. We are attached to them. In fact, the court has likened the cell phone to an appendage. I don't know the last time I've read a Supreme Court opinion where even appendages are described the way cell phones are described by the court. It's like we can't live without them. And she drew laughter during the oral argument because she mentioned that she knows of, our friend, right? She knows of young people who actually take their phones to bed with them. And so this whole notion of we can't get away from these wonderful bits of technology that, by the way, are communicating with that third party, cell tower, cell service, internet service provider, constantly without us engaging the item. And I think that was instrumental, at least for some of the rationale, in the distinguishing of this case and this state and this technology from the Miller-Smith line, the sort of dinosaur realm. And I say that because what the court said was, yeah, he did turn over this information, but there's no ability to do anything other than submit, if you will, to the Borg, right? Submit or perish, because why? Star Trek, folks. Because if, in fact, we are talking about voluntarily turning over one's information to a third party, then Smith and Miller still live to see another day and to be precedent elsewhere. This is not the case when it comes to cell phones and cell providers. There is, to extent, yeah, sure, some voluntary disclosure of location information, the court says, essentially to basically connect, to make calls, receive calls. But there is data, the data will be collected constantly without our even engaging the phone. And this is for, business purposes of the cell providers for sure. Their business records to see when you're roaming and when they can charge you more. But this is something that essentially the court is saying we can't help, and we can't help ourselves. And because this is where we are now, as opposed to where we were then, the court is saying this new phenomena needs to be treated a specific way. And so it says a lot in the decision, but ultimately the holding really specifically speaks to the ability of the government to get this information without a warrant based on probable cause. And it almost seems like a pedestrian holding, given all of what the court is saying in the decision. But the court is saying there should have been a warrant obtained, and that warrant should have, in fact, it would have covered the governmental conduct, but the warrant was not obtained. The document, the subpoenas and orders that they received weren't sufficient. So that's sort of one sort of category. I'm sorry, my time is up. One category of sort of what the court held. But what was phenomenal to me was the understanding before this announcement by Justice Kennedy that there might be a sort of conservative liberal alliance on the court when it comes to this technology. Not so fast. Not so fast. Because when you think about, and certainly some of the other decisions that were announced after this, Justice Kennedy was in the dissent here. And Kennedy's dissent was, and I couldn't understand it again now, understanding sort of how my co-panelists have characterized some of the decisions, these late decisions, these last decisions before the announcement. I can kind of now see the sort of, I'm out of here, I don't care, analysis in this decision. He dissented, and he actually, I think he dissented, yeah, he dissented, and Thomas and Alito joined him. He focused primarily on the Smith-Miller line of cases, and it's like, he was almost stubborn with it, like, you are turning this over, and you're turning this information over, and fine, if you're turning it over, we've got doctrine for that. And so this newness and this dependency and this pervasiveness, I mean, the technology is pervaded. When the court started off saying that there essentially are more cell phone accounts than people in the United States, I knew it was over then, right? And so the understanding that Kennedy brings to this line of cases, I agree, it's a mixed legacy to be sure, but I would say in the context of the Fourth Amendment, it's a little less than mixed, particularly when it comes to some of the areas that you would expect a Kennedy to be a bit more forward-thinking on. In fact, sometimes he seems a bit retro, and he certainly proved that in this decision. It was almost, there were points at which it seemed he was being unnecessarily dramatic. And I just, again, couldn't understand it, but now, after the announcement, I'm starting to get a better understanding of what, in fact, might have been going on.
All right, well, thank you so much. It will be really interesting to see, as people try and mine Robert's opinion and also Justice Gorsuch's dissent, for tea leaves for how you can attract maybe one of the conservatives in different areas of the law as they become the median justices without...
if you combine Gorsuch's dissent, which is really a concurrence in all but name in Carpenter, with Sotomayor's writing in Jones, I think that's the future. And well, at least that's what I hope it is, because I do think we need, not an overturn of Katz because there's no protection of privacy, but that is an analog decision. We need some sort of other rubric for the digital age.
And can I just add this too, that with Gorsuch's dissent, it was mind-boggling at points, because essentially what you saw, well, first of all, you have Thomas and you've got Alito, and there seemed to have been, I saw this on my timeline on Twitter earlier today, and I thought, wow, this is a concept. This notion that if, in fact, Gorsuch is occupying a so-called stolen seat, then he is joyriding in this dissent, when he essentially sort of brings up some great points about the sort of catch as catch cans jurisprudence of the Fourth Amendment, but at the same time, then he leaves us with nothing. And he seems to be saying, I've got some superior interpretation of the Fourth Amendment, but you can't have it. And I will keep it to myself until I decide at some magical, mystical moment to make it known to you. And I'm worried that magical, mystical moment will come with this next justice, because another sentiment on the timeline, Justice Roberts is the new swing vote.
But let me just make sure that we get to questions, because we only have 10 minutes left. So let's do that. If you would identify yourself, if anyone has a question that they want to ask, and we'll start with any of the members of the press who are here. We have microphones. I'll mention, so we're getting to someone that one of the other areas that may well be on the chopping block is the exclusionary rule. Justice Kennedy really was the fifth vote for preserving the exclusionary rule, and it now may get thrown out, to use a pun, entirely. Okay, here. Hold on just a second. Wait for the microphone, please.
My name is Eddie Eiches, and I was, for 20 years, a union president in the federal sector, which could arguably be the model, because Janice was union shop. But in the federal sector, most recently. And this is the third real loss, and you could argue that what Trump did with 3 executive orders was destroy federal, we were...
Can we just focus on the question?
Yes, please, I'm sorry. So we were given official time, and that's all gone, and arguably a result of the travel ban decision, the court challenges will be dismissed because of the executive order and the deference to the executive, and I just wanted your comments on that.
I'm sorry, comments on?
On the 3, the 3 executive orders that basically destroy federal unionism as it relates to the potential challenges will be, which are now in court, will be arguably dismissed as a result of the deference in the travel ban case.
So, Ben, do you have a sense of kind of where litigation goes from here?
I mean, it sounds like the question is really about deference to the executive under the travel ban case. Is that, if I understand, it's less a labor law question?
Well, just where do you see, in terms of, for example, public sector unions and their abilities to survive, do you think that there is going to be a wider range of challenges beyond the Abood question to just the notion of collective action?
Yes, I think that we're going to see a challenge to, and we're seeing a challenge to the principle of exclusive representation under the Constitution. And I think that's likely the next step in the attack on public sector
And do you think that there will be a carryover from the travel, I take this to be the question, from the travel ban context where they simply say, the executive branch gets enormous deference. Do you think that that, which is articulated in the national security sphere, will play out across other areas of the law? So, for example, they would defer to executive orders with respect to, organizing.
Potentially, I'm not sure they're going to need it. Yeah.
Okay, great.
Art Spitzer from the local ACLU, also for Professor Sachs. After Janus, do you think a union now has a First Amendment right to say, we're not going to represent non-union members in grievances and arbitrations?
It's something Ilya said, it prompted the same thought in me, which is that if and this is part of the holding, if everything a public sector union does is political speech, that would seem to imply a more robust set of protections for public sector unions. What comes up more directly in the opinions is the idea of more robust protection for individual public sector employees, or in Justice Kagan's articulation, what if a non-union group of public sector employees engages in a protest activity to raise their wages? That ought to be protected now by the Constitution. The truth is, of course, in multiple areas of law, we have a union-specific set of doctrines. And that the rule is that the union loses. And that will be the case. So in theory, should public sector unions now have more constitutional protections? Yes. Will they, in fact, secure them? No.
All right, let me make sure that we do take one bigger step back with respect to the impending confirmation fight in the last few minutes that we have, and I'll just ask kind of a lightning round set of questions. Do any of the panelists believe that there is a realistic prospect that a nominee who's not, assume nothing crazy is discovered about the nominee beyond ideology, any kind of personal craziness is discovered, does anyone see a path by which Democrats in the Senate or otherwise politically have any chance of blocking the nominee?
I think there's a very long shot. I wrote about this last night at Slate, that all the effort's going to have to be on Collins and Murkowski, and all about the question of abortion and women's rights, and to try to peel off a justice or two. But that, of course,
senator or two.
A senator or two. But that, of course, depends on Democratic senators like Donnelly and Manchin and McCaskill not folding, and Democratic senators running for re-election in Trump states.
But doesn't it also depend on the administration tripping up and nominating someone who has said something about abortion? Right? I mean, because isn't the other view that you could persuade?
Bill Pryor, I think, is the only one on the list.
Yeah, exactly. Bill Pryor, who's called it Roe an abomination. But assuming that they don't do that, the strategy to simply get a Republican senator to say that a Republican president can appoint anybody to the Supreme Court?
Well, so the question is how opaque the abortion issue or other issues might be to people. I said in order to put pressure on someone like Collins, you'd actually have to have massive street protests. And I think that's going to come. I just think it's going to come after Scalia 3 is appointed to the court and after we start getting some of these opinions that do the things that everyone besides Ilya on the panel is afraid about.
And what about timing? Does anyone believe that the hearings would go past the midterm elections, or is there going to be a motivating tool in the run-up to the midterm elections, but by the time we get to the fall, we'll have somebody on the Supreme Court?
I bet Jonah Goldberg a bottle of liquor that there'd be a justice by the start of the next term.
I see. Well, I assumed alcohol would be involved. Essentially a lock, no matter who it is, and that they'll be on the court by the time the next term starts in October, at which point all of these new challenges begin. Then the last question I have is, how aggressive do you think the court's conservatives will be, business groups will be, libertarian organizations will be, Cato being an example, in now starting to push a new generation of cases to the court, state legislatures in adopting restrictions on abortion, attacks on affirmative action, that sort of thing. Do you feel gearing up, given the inevitability of this, these new issues, strapping rockets to them and headed to the Supreme Court, or is there still a delay because you want to see what the new justice will do?
No, I think right away. I mean, to me, footnote 1 of Carpenter, it seemed as if just the Chief Justice was courting a Katz challenge, for example, in the Fourth Amendment context. It's sort of, well, we're not asked to overturn Katz today, in this case, and it's sort of throughout the opinion, there seemed to be some sort of courting of that case. I imagine that's coming.
I would worry.
I was just going to say, I think the answer is not right away. I think it's yesterday. I think that at least in the LGBT space, the challenges are already there. I mean, they've been planted around the country, percolating up, because we've all known that this day was going to come. And I think there was a real expectation of ultimately finding a more favorable audience at the court than they would have gotten, at least in the LGBT space. So we see, for example, Masterpiece K-Shop involves a fact pattern where our clients, Dave and Charlie, walked into a shop they were referred to by their event planner, with a photo of cakes, excited to talk about the cake, and are turned away and experienced that really very real and devastating harm. Our opposition has filed cases involving vendors that have never been approached by same-sex couples, but simply are seeking the right both not to serve them and to advertise that they intend to violate their state non-discrimination laws. And they have filed challenges like that in a number of jurisdictions, clearly teeing up this issue to get to the court in a way that they can control, because of course they can't control when a couple may happen into a shop. The same thing when it comes to students who are transgender. We've seen the success of students like Gavin Gramick getting courts to understand why it's wrong to bar Gavin from the boys' room. And our opposition has filed cases on behalf of cisgender students who say, wait a minute, my school is actually violating my constitutional rights simply by allowing transgender students to use the same bathrooms and restrooms as everyone else. So those cases too filed across the country. So these issues are not coming up just in instances where it's LGBT people who are experiencing discrimination. We're seeing a real affirmative push to go out there and look for these challenges. And I think it's unquestionable. The goal is to have a number of vehicles ready for the moment when the next justice is confirmed.
Just two quick things on this. Ilya said that Janice was brought by an individual worker. I mean, that's of course formally true, but there's been a lot of great reporting on the funding of these cases, and the legal representation is all consolidated, and there's numerous cases all around the country just waiting to come up on this. But I also want to highlight something Rick said, which is it'd be terrible if we all left this room thinking this was over and done. Mobilization changes political facts, and it's on all of us to hit the streets, as it were, and put pressure on the Senate to do the right thing here, and not to assume that we can decide today that it's over.
And not to assume that,
On criminal procedure, it really depends. If it's another Gorsuch, then I think we're fine, because even more than Scalia, Gorsuch is a big friend of constitutional protections for criminal defendants. Look at his opinion in DiMaia versus Sessions, a crimmigration case this term, where he was the only conservative joining the liberals in striking down a vague catch-all provision. He's very much of that mold, but not everyone on the list is. So on Trump's list, there are some who are like Gorsuch and Scalia with respect to criminal procedure issues that are very much civil liberty oriented and original meaning of the Constitution and all that. And there are some who are more law and order and deference to law enforcement. So that's definitely a difference to tease out. And until we know who the nominee is, we can't say for sure which way the criminal procedure winds will blow.
Rick, a final word? Oh, sorry.
Oh, but when it comes to Roe, I don't think we need to wait and see who the nominee is. I mean, the president has said openly that after he appoints several justices that Roe v. Wade will be overturned. He said it will happen automatically. That is what he has said. And I think our one takeaway from the Muslim ban case is that the president does what he says he's going to do. He promised a total and complete shutdown of Muslims entering the United States, and that is what he did. And I think we would be foolish to wait for the particular name. We know what the president's intent is with respect to Roe, and we can stop that now.
I was going to say, just a little quibble with your question. You said about waiting to see what the next justice is like. I would say the question is not what the next justice is like. The question is how John Roberts wants to move. So we've spent the last 11 years asking what Kennedy had for breakfast. Now is what did John Roberts had for breakfast. It's a slightly different menu.
Well, on that note, our time has expired, but join me, please, in thanking the panelists, and thank you all.
Now we can stand.